Can courts stop presidential executive orders? Imagine a situation where a president issues an executive order that significantly changes immigration policies or environmental regulations. The question arises, can the judiciary intervene to halt or modify such directives? Understanding the balance of powers among the executive, legislative, and judicial branches is essential to answering this question. Presidential executive orders are official directives issued by the president to manage operations of the federal government. They are based on the authority granted by the Constitution or delegated by Congress. These orders are a tool for presidents to implement policies without the need for new legislation. However, their scope and legality are subject to legal limits. Courts have the authority to review executive orders to determine whether they are consistent with the Constitution and existing laws. When an executive order exceeds the president's constitutional powers or conflicts with federal statutes, courts can declare it invalid. This process often involves lawsuits brought by individuals, organizations, or government entities challenging the order. The most prominent example of judicial review of executive orders occurred during the administration of President Franklin D. Roosevelt. The Supreme Court examined several of his orders, including those related to internment of Japanese Americans during World War II. The court upheld some orders but struck down others, establishing the principle that executive actions must adhere to constitutional limits. In recent history, courts have blocked or limited executive orders related to immigration. For example, in 2017, a federal district court temporarily blocked the implementation of a travel ban executive order issued by President Donald Trump. The courts found that the order likely violated constitutional protections and statutory laws. Similarly, courts have scrutinized orders related to environmental regulations, health care, and other policy areas. While courts can strike down or limit executive orders, they generally do not have the authority to completely prevent a president from issuing new orders. Instead, they serve as a check on executive overreach, ensuring that presidential directives do not violate constitutional principles or laws. Ultimately, the power to issue executive orders remains with the president, but that power is not unlimited and can be challenged in the judiciary. In summary, courts can stop or limit the implementation of presidential executive orders if they are found to be unconstitutional or unlawful. This judicial oversight helps maintain the balance of power among the branches of government and protects individual rights and constitutional principles.